Welcome, everybody. Thank you so much for joining us tonight. My name is Daniel Rothenberg. I'm co-director of the Center on the Future of War, and this is the final event of our 2021 Spring Speaker Series. We're really thrilled to have Ambassador David Scheffer joining us for a talk, Preventing Atrocity Crimes in a Violent World. So this event is co-sponsored by the Martin Springer Institute at Northern Arizona University. We have the director here. I'll give a brief intro in a second, as well as the ASU Global Human Rights Hub. And we have the director, Heather Smith Kenoi here as well. So really briefly, the way we run the events, for those of you who are joining us for the first time, is we'll do this short introduction. We'll go to Ambassador Scheffer's talk, and then there'll be a Q&A session. And we ask all of you who have questions to type your questions into the Q&A box in the Zoom feature. And then I'll play the role of moderator, and I will try to get to all the questions that are presented. And usually we do a fair job of that. So again, thank you for spending part of your Wednesday evening with us. Heather Smith Kenoi is the Associate Professor in Political Science, whose work focuses on human rights and international law. She's the director of the Global Human Rights Hub, a pan-ASU research initiative housed in the School of Social and Behavioral Sciences. She's especially interested in the effects of international law on the rights of women, and her other research interests include sex trafficking, women and children's rights, public health, migration, and statelessness. And she'll say a few words about the Global Human Rights Hub. We're also joined by Bjorn Krondorfer, who's director of the Martin Springer Institute at Northern Arizona University, and also an endowed professor of religious studies in the Department of Comparative Cultural Studies. He works on religion, gender, and culture, as well as post-Holocaust and reconciliation studies. He's the author of many books, and including most recently, Unsettling Empathy, Working with Groups in Conflict, and The Holocaust and Masculinities, Critical Inquiries into the Presence and Absence of Men. So Heather, if you could just say a few words about the Human Rights Hub, and then we'll turn to Bjorn.
Thank you, Daniel, and welcome, Ambassador Scheffer. As Daniel explained, I'm the director of the Global Human Rights Hub. We're an interdisciplinary research initiative housed on ASU's West Campus. And we bring together faculty and graduate students from across ASU's 4 campuses that are working on issues related to international law, gender, migration, and human trafficking. We hold working group meetings a few times each semester for affiliated faculty and students. And we also run a graduate fellows program that links ASU graduate students with faculty mentors. We're very excited to be hosting an NSF-sponsored conference next month, Human Rights on the Edge, the future of international human rights law and practice. So please check out our website for more of our events and consider joining one of our working groups. Everybody in the ASU community is welcome. We're very excited to be hosting this event with the Center on the Future of War and the Martin Springer Institute. And thank you for being here, Ambassador Scheffer.
Thank you, Ambassador Scheffer. This is going to be a really wonderful event this evening. Our institute, called the Martin Springer Institute, was founded by Doris and Ralph Martin. Doris is a survivor of the Holocaust from Bernstein in Poland. She's still alive, she's 94. 20 years ago, they made a donation to make it possible for this program and institute to run at Northern Arizona University in Flagstaff. So we have 20 years of programming behind us. And our dual mandate is to look at the legacy of the Holocaust, but really also bring it up to issues today, the current conflict, the current crisis, where there's grave injustice or harm done to communities, and to look for ways of repair, reckoning, reconciliation, whatever terms we need to address particular situations. So the subject today is very close to the mission and the heart of what we do when we talk about the prevention of atrocity crimes in an increasingly violent world. And I'm very happy to work with ASU and to coordinate and hope for future event. Just one word about of the many things we do. This fall, we're going to have an international conference that looks at the legacies of the Gulag and the legacies of Auschwitz in comparative perspective of how different countries, different communities dealt with these or haven't dealt with these legacies, especially when talk about Russia. The question is how extensively it was dealt with. So these are the kind of things we do, and I'm looking forward for tonight's talk.
Dan, we can't hear you.
Thank you so much, Bjorn and Heather. Ambassador Scheffer will be introduced by our colleague, Stephanie Lindquist, who is the Senior Vice President of Global Academic Initiatives at Arizona State University, where she facilitates ASU's global academic portfolio. Prior to that position, she served as Deputy Provost and Vice President of Academic Affairs, as well as Foundation Professor of Law and Political Science at ASU. Previously, she was Dean and Arch Professor at the University of Georgia's School of Public International Affairs, as well as Interim Dean, Associate Dean for Outreach, and Associate Dean for Academic Affairs at the University of Texas School of Law. She's an expert on the U.S. Supreme Court, constitutional law, and administrative law. And briefly, our center is something of a family, as you can see here, those of you who are less familiar, and we're just thrilled that you're joining us and that we're able to put together this event. And thank you so much.
Thank you, Dan. And so pleased to be associated with and affiliated with the Center on the Future of War and with you. And so pleased to be able to introduce Ambassador Scheffer this evening. I met him for the first time March of 2020. And that was his last trip, as I understand it, he told me, before the coronavirus to meet with us in Washington, D.C. And it was a pleasure to meet him. And I'm so pleased that now he is affiliated with ASU and that he is giving this presentation this evening. So thank you so much, Ambassador Scheffer, for being here. I think all of you on the call understand the significance of his career. Up until recently, he was the clinical professor emeritus and director emeritus of the Center of International Rights at the law school at the Northwestern University School of Law, where he and I share many experiences and former colleagues. From 2006 to 2020, he was the Meyer Brown Robert A. Helman Professor of Law at Northwestern, and from 2006 to 2019, the director of the Center for International Human Rights, where he taught international criminal law, international human rights law, and related subjects. He is also, I think currently, the Vice President of the American Society of International Law, a visiting senior fellow of the Council on Foreign Relations, and the Tom A. Bernstein Genocide Prevention Fellow at the U.S. Holocaust Memorial Museum. So that's incredible. From 2012 to 2018, he was the UN Secretary General's special expert for work on UN assistance on the Khmer Rouge trials. And he was the first ambassador at large for war crime issues from 1997 to 2001. And he led the US delegation of the UN talks establishing the International Criminal Court. Incredible. He signed the Rome Statute of the ICC on behalf of the United States on December 31st, 2000, in the year 2000, and negotiated the creation of 5 war crimes tribunals and chaired the Atrocities Prevention Interagency Working Group from 1998 to 2001. I also want to point out that he received the Berlin Prize in 2013 and the Champion of Justice Award of the Center for Justice and Accountability in 2008. Foreign Policy magazine selected him as the top global thinker of 2011. So Ambassador Scheffer, we are so grateful for you being here with us this evening, and we look forward to hearing you about this important topic related to atrocities. So thank you again for being here. Thank you for joining us at ASU for this important event.
Well, thank you so very much, Steph, or I should say Senior Vice President and Professor.
Oh, no, Steph works.
Thanks for that generous introduction. And thank you to Professor Rothenberg and the ASU Center on the Future of War, and to Director Krondorfer of the Martin Springer Institute and Director Heather Smith of the Global Human Rights Hub for this exceptional opportunity to address a subject that has been part of my life and work for more than 30 years. And frankly, to all, happy St. Patrick's Day from an Irish American whose relatives migrated to Newport, Rhode Island in 1848 during the Irish potato famine. COVID-19 and its associated public health emergency, climate change, the rise of authoritarianism, massive refugee populations, the unending assaults on human rights, the economic recession imposing an unbearable hardship on hundreds of millions across the globe, all are of the highest priority. But so too are the continuing threats and realities of atrocity crimes. Governments, international organizations, particularly the United Nations, civil society, and the academic community must not let all of these other crises and challenges, each of deserved prominence today, overwhelm the continuing importance of and focus on preventing atrocity crimes. vanquishing such violence when committed, and achieving accountability in the aftermath. To understand, we need only mention the atrocity fields of Syria, the humanitarian catastrophe in Yemen, the Rohingya of Myanmar, the Uyghurs of China, victims throughout Central Africa, the tribes of Darfur, the oppressed of Venezuela, and millions of civilians in North Korea. For if one tries to comprehend the larger realm of human suffering, the horror unleashed by atrocity crimes knows few parallels. Like all of the other crises we face today, atrocity crimes are phenomena conceived and perpetrated by humans who unquestionably hold the power of prevention. Indeed, a year ago, I wrote about the public health malpractice that has now led to hundreds of thousands of deaths, what science journalist Laurie Garrett goes so far as to label pandemicide, which may have started with wildlife, but human decisions led to its deadly expansion. But there are 4 distinct prevention issues I want to briefly cover in this address, and this will take no more than 25 minutes. First, over the last 2 decades, usage of the term atrocity crimes has taken hold at the United Nations and the International Criminal Tribunals and among governments, scholars, NGOs, and the media. Atrocity crimes are genocide, crimes against humanity, serious war crimes, and very often aggression. When I introduced the term in 2001 in a law review article, I did so because of the failure of terminology during the 1990s when I served in the Clinton administration. Policymakers must act to prevent and repel atrocities quickly without waiting for legal advisors to determine whether or not the high bar of genocide has been achieved. It is a heinous and colossal crime, but nonetheless, it is one of several types of atrocity crimes. Because what transpires in violence-burdened societies is not only genocide, but also crimes against humanity, serious war crimes, and sometimes aggression. And all of these crimes deserve high priority attention by policymakers as they loom on the horizon or immediately when they break out, regardless of precise definitions. So I had an agenda 20 years ago, namely to level the playing field and in fact focus on prevention. Regardless of how tribunals and scholars ultimately define the category of crime involved in any particular act or conflict, policymakers must react in real time to prevent the commencement or continuation of such crimes, and they must recognize that such violence is potentially criminal. Make no mistake, complicity in the commission of atrocity crimes can include the failure to prevent them when a government knows of the circumstances unfolding, has some capacity to react, and yet fails to act. I had my own experiences in this respect with Bosnia, which I wrote about in my most recent book, The Sit Room, and in Rwanda and Kosovo, which I also write about in All the Missing Souls. So act, one must, as a policymaker. Using the term atrocity crimes without getting bogged down in whether it is genocide or crimes against humanity or war crimes should be enough to trigger decision-making on prevention, be it diplomacy, economic or trade sanctions, international litigation, or the positioning of military assets or even armed intervention. Granted, the term genocide can be extremely powerful, and I have championed using it for the Rohingya and the Uyghurs today in endeavors with several NGOs and in connection with the Gambia's case on genocide against Myanmar regarding the Rohingya before the International Court of Justice, in part to galvanize international action with determination that draws upon best estimates of what has actually happened. Prior to August 2017, for example, policymakers should have been seized more prominently with the prospect and sometimes reality of atrocity crimes against the Rohingya, and they should have focused at least diplomatic efforts on preventing the worst outcome. Governments failed the Rohingya prior to August 2017, and it is incumbent upon them not to fail the Rohingya now. One small step would be for the United States to join the Gambia case at the International Court of Justice. Regarding the Uyghurs, one can fairly pronounce that over the last several years, atrocity crimes, regardless of how they are precisely defined, have been unleashed on that ethnic minority. Governments should have been far more focused in that respect than they have been, because now the atrocity crime of genocide has been and is being institutionalized by the Chinese government against the Uyghur ethnic minority. That does not mean mass executions, but rather a combination of some killings with mostly the 4 other acts of genocide found in the Genocide Convention. Last week, I joined with many other international experts to issue a report reaching the conclusion that, based on open source reporting, the US State Department's own determination recently, and documentation, the Chinese government is committing genocide against the Uyghur population of Xinjiang. Indeed, we conclude that all 5 acts of genocide under the 1948 Genocide Convention, which China ratified in 1983, are being systematically committed by a highly organized and bureaucratized policy led from the highest levels of governmental authority. After years of this slow motion genocide unfolding in Xinjiang, we concluded that the open source evidence requires that the atrocity crime of genocide be called out. Let the Chinese government disprove us rather than issue specious denials that fool no one. Beijing should invite the UN Human Rights Council to form an independent commission of inquiry to visit Xinjiang and Beijing for a full and unimpeded investigation of the large number of reported killings of Uyghurs under highly suspicious circumstances, of the hundreds of newly constructed detention centers where 1 to 2 million of the 11 million Uyghurs reportedly have been corralled behind razor wire walls, of the hundreds of thousands of imprisoned Uyghurs, including the ethnic group's leaders, of the forced labor factories, of the practice of forced sterilizations, abortions, and forced implantations of IUDs in women, of the rampant rapes and sexual violence in the detention centers, of the unlivable conditions imposed upon the Uyghurs who are under constant surveillance, and of the forcible separation of Uyghur children into state-sponsored orphanages and re-education centers where their Uyghur language and culture are purposely erased. It is the obligation of not only China, but of other ratified states parties to the Genocide Convention, like the United States, quote unquote, to prevent and to punish the crime of genocide. We need not, in fact, we must not wait for years until there is a criminal court verdict of genocide against an individual Chinese official in order to act under the Genocide Convention. At this stage, governments must step forward to make a determination of state responsibility for genocide under a clear and convincing standard of evidence that can be inferentially drawn from the open source information and, where possible, intelligence findings in order to prevent further genocide and to prepare for the day of accountability, be that at the governmental or individual level of liability. Particularly before this distinguished audience, I am not suggesting any military action, particularly with respect to China, as the word prevent does not require military intervention as a state party's fulfillment of the obligation to prevent genocide. The US government already has made a determination of genocide with respect to the Uyghurs, and the Biden administration has held firm to that determination. Many diplomatic, economic, and trade, cultural, sports, cyber, and other types of actions can be taken far short of military intervention to prevent further genocide of the Uyghurs. And I strongly believe such steps should now be considered for the sake of the existence of the protected group, namely the ethnic minority of Uyghurs in China, in the years ahead. Let it not be the case that when later generations are asked what became of the Uyghurs, the answer lies in the inaction of governments to recognize and act in the face of massive atrocity crimes, including not only crimes against humanity, but also genocide. Second, several years ago, I began to focus on the actual costs of prevention of atrocity crimes in comparison to the enormous expense arising from the failure to prevent atrocities, including the actual financial burden of the atrocities when they occur, and the astronomical monetary and non-monetary costs associated with the restoration of devastated societies victimized by atrocities. We need to make progress in determining how costly atrocities actually are in terms of human lives, in the viability of economic well-being, in the cultural and intellectual fiber of society, and in the moral compass of peoples. Without this knowledge, policymakers are deprived of the critical data they need to understand the consequences of their inaction with respect to atrocities. The range of costs needs to take into account not only the heterogeneity of different atrocity scenarios, but also that prevention can be promoted through a wide range of investments in societies at risk. What would be the most effective investment strategies for the cost determination methodology of preventive measures? Well, the first category of cost of prevention should entail research into fairly predictable areas of budgeting, such as costs relating to UN peacekeeping or coalition military deployments, economic sanctions, economic development and humanitarian assistance, and the costs of promoting democratic institutions and the rule of law. Importantly, such calculations should distinguish between the costs of indicators of atrocities, namely long-term trends that raise grave concerns, and similar costing calculations for precursors of atrocities, which are the immediate threatening signals that violence is imminent. The goal would be to determine the costs of monitoring and responding to such indicators and precursors for the purpose of ultimately resolving the threats before mass atrocities erupt. The second category would be the actual cost of atrocities, assuming they are not prevented, and thus their impact on society. These costs include the loss of human life, the infliction of injuries on thousands, mental illness and post-traumatic stress disorder, the loss of earning capacity for impacted families, the destruction of the judicial sector and educational systems, the devastation of property associated with victims of the atrocities, destruction of cultural monuments and sites, the cost of massive refugee flows, and the cost of moral decay within the affected societies. There is an additional dimension to the cost of atrocities, constituting the third category, that typically has not been accounted for in conventional thinking, namely, the funding required for restoration in the aftermath of atrocities, which can far exceed the financial burdens under the first and second categories. The past value of what is destroyed during atrocities is far less than what it would take in human and financial resources to rebuild devastated societies, typically over decades. The cost of restoration includes the current and higher market value of rebuilding homes and businesses, of meeting the medical needs, physical and mental, of perhaps millions of survivor victims for decades, of restoring judicial and governmental institutions and cultural sites over many years, of returning refugees to their communities or assuring their livelihoods elsewhere, and of rebuilding the society's infrastructure, energy, transportation, hospitals, schools, etc. Then there is the growing reality of reparations that governments either agree to pay voluntarily or by treaty or by order of a national or international court. Are those probable reparations factored into decision-making at the beginning of an atrocity situation? My hope is that the day will arrive where in the Situation Room of the White House, when a potential atrocity crime situation is discussed at that table, policymakers would be presented with a financial estimation report, comparing the cost of prevention with that of actual commission of atrocities and then of restoration and reparations. Once confronted with those three categories of estimated costs, policymakers might be more inclined to deliberate about steps to prevent atrocity crimes, rather than procrastinate and confront them in real time or restore the devastation left behind. The moral dimension of preventing atrocity crimes, of course, remains paramount. But if the raw calculation of the financial impact leads to a more effective atrocity prevention strategy, then I am all for it. Third, I co-authored a book chapter for a volume edited by Professor Layla Sadat and published in 2018 by Oxford University Press. The chapter is entitled 21st Century Paradigms on Military Force for Humane Purposes. My co-author was Angela Walker. She and I argued that new paradigms for using military force to prevent or repel atrocity crimes should be examined. The book chapter essentially picks up and expands upon the thesis I advanced 30 years ago in my law review article entitled Toward a Modern Doctrine of Humanitarian Intervention. Now, much has transpired since then. The current regime of law based on the UN Charter and the responsibility to protect principle, however, has been disappointing in achieving the goal of preventing atrocities. Of course, there is scant political sentiment anymore in this country or abroad, as far as I can determine, to realistically implement R2P. And this despite the rhetorical support many governments express for it in the annual General Assembly debate, and despite the valiant support of civil society, including one of my favorite NGOs, the Global Center for the Responsibility to Protect. The first paradigm in the book chapter examines 4 UN Charter provisions and practices, namely the possibility of a political agreement to effectively overcome the veto power held by the permanent members of the Security Council when humanitarian crises arise, reactivating the Uniting for Peace resolution, resorting more frequently to UN peacekeeping forces under so-called Chapter 6.5 authority for humanitarian actions, and negotiating Article 43 standby force agreements between member states and the Security Council. The second paradigm explores a more pragmatic and hence expansive interpretation of Articles 2, 4, and 51 of the UN Charter and the customary law right of individual and collective self-defense. This paradigm, grounded in the UN Charter and customary international law, would enable a more effective application of the use of military force in the face of humanitarian debacles, whether driven by atrocity crimes or by other repressive assaults or natural calamities. The third paradigm reaches beyond conventional UN Charter theory to recognize what we term as the exhaustion principle, namely a situation where UN Charter procedures are exhausted and the humanitarian situation remains dire. A military intervention launched onto foreign territory where the humanitarian crisis is erupting, but where UN Charter authorization, literal or interpretive, remains absent, is a gamble under the law. It may, however, eventually find a basis in customary international law, where human rights principles can influence the morality, if not legality, of the initiative, thereby leading to the acquiescence of other nations. These paradigms could establish the basis for a new doctrine of humanitarian intervention in the 21st century. One can envision all of them working together as a framework for action, where one paradigm may fail in a particular situation, another paradigm might replace it, depending on the circumstances of the humanitarian peril and the all-important question, if not now, when? As a strong believer in the Rome Statute of the International Criminal Court, I nonetheless am concerned about how to advance the law of humanitarian intervention in light of the crime of aggression now embedded as an operational crime in the Rome Statute. The definitions for the crime of aggression and an act of aggression set forth in Article 8 bis of the Rome Statute do not envision the legality of humanitarian interventions falling outside of Security Council authorization under Chapter 7 of the UN Charter, unless one occurs squarely within the inherent right of self-defense without triggering a manifest violation of the UN Charter. The activation of the operative crime of aggression in the Rome Statute thus may create a new and daunting disincentive for any nation considering how to respond to a serious humanitarian situation that is a compelling one for military intervention. There will be some countries that will not be subject to the International Criminal Court's scrutiny of their leaders for the crime of aggression. There will be non-party states and states parties that have opted out of liability for the crime. But for those countries that ratified the amendment for the crime of aggression and embrace its coverage, the prospect of persuading such governments to step up to the challenge of a military intervention for humanitarian purposes likely will be undercut by the Rome Statute's operational coverage of aggression. One way to overcome this problem would be to amend the Rome Statute's definition of an act of aggression so that it explicitly includes, quote, acts that are in exercise of the right of self-defense under Article 51 of the Charter of the United Nations, or of the responsibility to protect under United Nations General Assembly Resolution 60/1 of 24 October 2005, close quote. Although this would not cover the exhaustion principle, at least it would undeniably recognize the legality of self-defense and R2P grounds for a forcible humanitarian intervention, and thus exclude individual criminal responsibility from the normative framework of the crime of aggression when armed force is used for these purposes. My fourth and final point is that the United States Congress has been relatively busy on the atrocity prevention front in recent years. I count at least 6 laws within the last 3 years that bear upon atrocity prevention, including the prospect of accountability for atrocity crimes already committed. The new laws bearing upon accountability send a strong message of deterrence and hence potentially of prevention. The most relevant law is the Elie Wiesel Genocide and Atrocity Prevention Act of 2018, which places the prevention of atrocities squarely in the national interest and stipulates a bureaucratic and reporting regime that should keep the US government informed and incentivize officials to engage with allies and others to prevent atrocities. Other laws include the Iraq and Syria Genocide Relief and Accountability Act of 2018, the Caesar Syria Civilian Protection Act of 2019, the Saudi Arabia Accountability and Yemen Act of 2019, the Sanctioning the Use of Civilians as Defenseless Shields Act of 2018, and the Uyghur Human Rights Policy Act of 2020. The Uyghur law imposes property blocking and visa blocking sanctions on individuals and entities identified as responsible for human rights abuses in China's Xinjiang Uyghur Autonomous Region. It requires the president to report to Congress on human rights abuses in that region, efforts to protect ethnic Uyghurs and Chinese nationals in the United States from intimidation by the Chinese government, and the Chinese technological developments that are enabling mass surveillance and internment. And I note that in April 2019, for the first time in history, both houses of Congress passed war powers legislation that called for an end to US involvement in the war in Yemen. However, it was subsequently vetoed by former President Trump, and yet President Biden has already moved in that direction by executive action. This year, I want to finish a 12-year journey to see the United States Congress pass and the president sign a Crimes Against Humanity Act. This has been an impunity gap in US law that I have written about, and it is legislation I've been associated with for more than a decade. I chair the American Bar Association Center for Human Rights Working Group on Crimes Against Humanity for this express purpose. It is a bill originally sponsored by Senator Dick Durbin of Illinois and Senator Patrick Leahy of Vermont in June 2009. The time has arrived for it to become law, as Senator Durbin is now chair of the Senate Judiciary Committee and has expressed a keen interest in its adoption. So the mission for 2021, and I invite all of you to join in this quest, is to realize the enactment of a law that would empower federal courts to prosecute crimes against humanity, including by foreigners who step within US jurisdictions. That would be one more deterrent to the commission of atrocity crimes. Recall that years ago, US law was amended to facilitate the prosecution of genocide and war crimes and the use of child soldiers. And now we must add crimes against humanity, as so many other countries have done in the last couple of decades. So thank you to all of the sponsors of this address for this opportunity to speak today about these issues. And now I am very happy to open up to your questions. So thank you very much.
Ambassador Scheffer, thank you so much for that really excellent presentation. It's great to see you here. And also, it's great that you're now going to be joining the ASU faculty as a professor of practice. We're thrilled about that. The paperwork is moving forward. You mentioned a number of issues that are really at the core of accountability writ large globally, and really kind of in some ways, a very hopeful presentation, particularly with that long list of recent congressional legislation, which I think people are maybe less aware of in light of all the other things happening in this country and around the world, and the pandemic and other issues. So you also focused on the costs, the importance of directing attention towards the incredible costs of atrocity crimes. I'm wondering, with the enormous amount of research and the commitment you've had to these issues, whether you've been able to take away from your studies and from your advocacy an understanding of which levers are most effective for actually convincing states with power to take the sorts of action that makes a difference on the ground in terms of either preventing or punishing atrocity crimes.
Thanks so much, Dan, for that excellent question. Boy, does that take me back to the 1990s when the issue of how to persuade foreign governments to join the US government in building and financially supporting, and also supporting in many other ways, a good number of war crimes tribunals put me to the test, certainly, on how to persuade other governments to join in these ventures. I think, and this is something that the Biden administration, of course, has sort of highlighted in the opening weeks of its own administration. And that is that first and foremost, the United States is going to have to set an example on all of these issues in order to persuade other countries. I've written elsewhere recently that we're entering a phase now in US foreign policy of which this issue of prevention is very much a part of, where we really cannot see ourselves as leading. Now, I know that sounds counterintuitive to most Americans, but we've had a rough patch overseas in recent years with our reputation and our lack of participation in collective and multilateral endeavors. It's going to take quite some time to overcome that. I deal enough with foreign officials and scholars all the time to know that, quite frankly, most of them are not looking to the United States. So for us to now try to bring them into a common view of these various strategies for how to prevent atrocities, if we want to keep our focus on that issue, that's going to require that we actually take sufficient steps. Now, we have done that legislatively in so many different ways, ironically, under the past administration. They are quite focused with respect to groups that, at least in recent years, the United States has wanted to actually focus attention on, whether it be in Iraq or Syria or the Uyghurs. The one act that has a much broader scope is the Elie Wiesel Atrocity Prevention Act of 2018. And so what I would hope is that one of the first steps we take is, first of all, demonstrate by example that we're taking on these issues extremely seriously. And we've started doing that, particularly with the Biden administration's reaffirmation of the Uyghur determination, which was a controversial step to take, given that that was made on the very final day of the last administration. And that generated criticism. But also, I would hope that in re-entering international organizations, the UN Human Rights Council, et cetera, that we're able to start sharing and collaborating in dialogues on this issue. I think it would be a mistake for us to walk into any multilateral room today and somehow presume that we will lead the discussion, that we will be the leader in doing what's right in the world. Rather, we need to sit down and collaborate with others to strategize that. And the prevention of atrocities is clearly one area where we can make a lot of progress in doing so.
Thank you so much. A question here from a colleague in the School of Political Global Studies, Pam Delargy, who's done an enormous amount of work around the world. The U.S. admonishes the current atrocities in Tigray, northern Ethiopia, seem not to have made a dent in the Ethiopian government's policies, in Eritrean involvement or Russian or Chinese resistance in the Security Council discussions. What do you foresee the Biden administration doing to try to influence this increasingly worrying human rights situation, which now has regional implications?
Yeah, this is one of the tough ones emerging on the scene within the last couple of months, and I'm not personally cognizant of what the Biden administration literally has done so far with the Tigray. I'm sure that there have been statements of, in fact, I'm positive there have been statements of concern and, in fact, possibly of condemnation from the State Department podium. I'm not aware of any from the White House podium yet. So the first step has to be a public set of statements that address this issue. Secondly, we should be corralling, which we may be already, and I'm simply ignorant of it, as much humanitarian assistance as possible. Remember, so many of the refugees of Tigray are spilling over into Sudan and possibly, I think, into southern Sudan. I'm not certain, but certainly into Sudan. And that should be all hands on deck with respect to humanitarian assistance. And quite frankly, I would put the greatest amount of pressure, I would hope the administration is putting the greatest amount of pressure on the Ethiopian government, which is an easier target to put pressure on than an authoritarian government of a character that we have difficult relations with. A sufficient amount of pressure to certainly get the humanitarian situation under control within the displaced persons camps, et cetera, within the Tigray region. But then finally, if the United States can be credibly active again in human rights forums and at the United Nations, I would not put it beyond our government to be able to take a collaborative role with other concerned governments to condemn the actions of the Ethiopian government itself, as well as the Eritrean forces, which are being used in militia and other ways to actually attack the people of Tigray. So there's a lot there that can be done from a condemnatory, from a humanitarian assistance role, and certainly, and again, I don't have full knowledge of this, if we're providing any military assistance to the Ethiopian government, that's leverage number one. That has to stop during this kind of repression and assault on the people of Tigray.
Question here from Peter Pisano. Welcome to ASU, Professor Scheffer. Best news of the year. May I ask about your great ideas on financing international criminal tribunals more effectively? And second, your thoughts on Colombia and its ongoing transitional justice experiment. And third, how can we help with the Crimes Against Humanity Act? Should we call Senator Durbin? Thank you.
Oh, I love those questions. I don't know if he's from the faculty or not, but maybe I just don't know. But yeah, I mean, I'm going to have to give you very short answers, obviously, to these three powerhouse issues that you've raised. One, on financing the tribunals. I haven't talked about any of that in my address today, but frankly, that's been kind of my primary focus for the last year with my Holocaust Museum Fellowship, and there will be a final report on this issued in a few months as to innovative ideas of how to generate funds in the private sector, first and foremost to assist the victims of atrocity crimes, But secondly, I would ultimately hope that it could be used for international justice to help finance the growing costs of the tribunals. There is a reality. Governments do not want to pay for these tribunals. I mean, they will pay some, of course, and I spent all of my years as ambassador persuading governments to pay for tribunals. And I spent my 6 years at the UN as the Secretary General's special expert, coaxing $30 million a year out of governments to pay for the Khmer Rouge Tribunal, the Cambodia Tribunal. That is tough work. And it has to be repeated year after year, and it places justice on a scale of problematic funding, which we're not used to here in the United States. We don't talk about, well, who funds the national courts, et cetera. Well, they just get funded. The Justice Department does get funded. The FBI does get funded. Well, when you bring all of that into the international arena and into international tribunals, where also the costs of defense counsel have to be covered, this is a huge issue. And it's based essentially on voluntary decisions by governments, or if they're states parties to the International Criminal Court, yes, they have assessments, but by gosh, do they try to influence what that will be each year in terms of approving or disapproving the budget of the court. So it's a huge issue. And I think you'll shortly see a very long final report out of the museum that is going to try to provide some answers to these vexing issues. My only anecdote to this, because there's so much to talk about, but this all came to me as I was flying over the Pacific, I don't know, in 2016 or 2017 for the Cambodia Tribunal, you know, once again, trying to raise money. I think I was bound for Japan that day. And I just said to myself, I looked out the window at this sort of Arctic ice outside, and I said, by God, there has to be a better way than this. This is crazy. And so that's what got me started to thinking about there has to be a better way to actually finance these things. Now, I think you were asking about Colombia, and I can't remember what the exact question was, Dan, about Colombia.
Really just a reflection on the transitional justice process that is going on in that country.
Ah, yes. What a story that is. With it's like a roller coaster. And I think the real story there is the International Criminal Court's patience with Colombia to try to find its own way on the issue of accountability. I think scholars for years are going to examine whether or not the ICC's patience was the right move, as opposed to taking up Colombia itself for purposes of accountability. They did not do that. It remained in preliminary examination, not in investigation. And I do think it is to the credit of the Colombians that they have finally reached this point of trial work. It has taken a long time, and I'm very aware of a part of the Colombian government that has tried to undermine this process, or political parties that have. So I would just say, yes, this is a uniquely complex, extended effort at transitional justice that I certainly hope at the domestic national level will in fact be achieved. But it has been a 20-year venture almost. And then third, on the Crimes Against Humanity Act, what can be done? We're right in the middle right now of a strategic working of this. We have a draft bill that's been kicking around since 2010. We're working closely with Senator Durbin's office. I would say that within a short period of time, I would hope that we'll reach a point where there's a draft bill that actually can be then circulated on Capitol Hill, and co-sponsors sought for that bill. I would say that general approaches to members of Congress on just the general point that the time has come to fill a gap in federal criminal law, and that gap is crimes against humanity, that moment has arrived, and that one encourages members to work towards adoption of legislation that will be, I mean, I can't speak for Congress, of course, or for Senator Durbin, but he certainly has a very deep interest in moving this forward, both in the Senate and of course in the House. So I would say just general expressions at this point are fantastic to start to stoke that, because we'll be approaching individual members of Congress as we have in prior years, but during the last administration, we had to hold off a bit, but now we'll approach these members again. So everyone's going to be contacted on Capitol Hill ultimately, I think within the next number of months.
Thank you so much. A question here from David Cater, Professor Emeritus from the San Diego O'Connor College of Law at ASU. Understandably, the learned presentation was deeply grounded in the law. However, I think we can appreciate the reality that only those nations with sufficient resources and power, not to mention political will, to act, and to enlist the participation of other nations to prevent atrocities. In short, the US, for example, needs to lead, set an example domestically and internationally. Now, you've addressed some elements of that, but I was wondering, this is a comment from a colleague, a law professor, speaking about the limitations of law in this instance, and maybe just some additional reflections on that situation.
I fully subscribe to that. This is very much also a political endeavor. It requires a political will. First and foremost, even before you talk about the law in the context of any of this, you really have to have a discussion about what is the political will of governments, including our own, to take something like this on or to be consistent with it. Now, we express our political will oftentimes in domestic legislation, and those acts that I just spelled out is actually an expression of political will by typically members of Congress. It was not led by the executive branch of the last administration. It bubbled up and came forth within the legislative branch of the government, very much expressing the political will of lawmakers and bringing the merit of that to the executive branch's attention. So, you know, if law is not combined with tangible actions, and I'm saying this very simplistically, of course, but if it's not combined with the kind of political diplomacy and economic diplomacy that you really need to exercise in this, you know, field of work, then the law itself will be quite shallow. I mean, bear in mind that a lot of countries around the world have national laws in place with respect to war crimes and genocide and crimes against humanity, and yet they're not being adhered to whatsoever. So at that point, you do have to look to the expressions of political leverage and will first and foremost. So this is very much a political science issue as much as a law one.
A question here from Mick Jordahl. The Trump administration has tried to sanction and prevent the work of the International Criminal Court, efforts that have not yet been reversed by the Biden administration. Could you address reversing this trend?
Yes, my goodness. Does that occupy much of my time these days with my NGO colleagues in the world, as well as many academics, of course, as part of that discussion. You know, some of my colleagues in academia have even filed lawsuits and are seeking, in one case, one federal district court did put an injunction on that executive order. I have 3 other scholars in academia who filed another lawsuit, and that the federal, they just sought from another federal court the same kind of injunction as delivered in the first one, so that they're covered too by an injunction. And they are expressing great frustration that the Biden administration has not simply rescinded this executive order so that these types of actions in the district courts are not required by them. Now, I will say that I understand recently, but don't hold me to this because I haven't researched this myself, but I heard recently that the executive order has an expiration date to it under the National Emergency Powers Act of June. I think that is correct, but I'm not positive. Now, it may be that the Biden administration is simply saying, let it expire. And that's, of course, when a new prosecutor comes on deck anyway. Karim Khan is in June of 2021. I would hope that that is not the actual decision, but rather that I would have thought the Biden administration would simply say, this is not an executive order which we are going to enforce. That's step number one. We're not going to go to the Treasury Department and say that there are any individuals that we're going to place on a Treasury Department list under the executive order. But then secondly, after that kind of decision is made, if they need a few more weeks, fine, but then rescind it and take it off the books, because that would send a very powerful signal internationally that we're not trying to hold members of the judiciary hostage to some sort of political agenda of the United States.
Thank you. A question for Mariah Mori. Are there any specific past presidential actions that would now be considered war crimes that, if not taken, would have genuinely resulted in less security for American citizens? And do you think this is a good argument for not having a Crime Against Humanities Act, that we would easily be at least complicit? I am for the act, by the way, says.
Yeah, there were several negatives in that, Dan, and I want to be sure I understand that question, because I have trouble when there are lots of negatives in one statement.
I think there's 2 points. One is can we think of, say, recent presidential actions that one could understand? This is a big question, perhaps, but as examples of war crimes, or maybe more specific to this issue as crimes against humanity, such that if we put into federal law crimes against humanity, then would that then place an added burden on the executive? Right. In the case that somebody in the executive, either the president or somebody else, might be charged with this crime? I think that's what the question is getting at. Well,
first, I actually don't think so. I mean, the example that would first come to my mind would be, well, has the provision of munitions to the Saudi Arabians and the UAE, which were then dropped on the civilian population in Yemen, those were US munitions, and in the early stages assisted by the United States Air Force in terms of logistics of the air campaign against Yemen. Would that be a crime against humanity? That's a serious issue. A lot of us have always been objecting to what the United States was doing in providing those munitions. But I would categorize that more in the war crimes category than crimes against humanity, because crimes against humanity requires that there be a widespread or systematic assault by the perpetrator government on a civilian population with knowledge of that attack, and at least under the jurisprudence of the ICC, pursuant to some kind of state policy to actually execute a widespread and systematic assault on a population. I don't think that's exactly what we were involved with in Yemen. I would say it could be more associated with the possibility of war crimes. And under that scenario, we already have a War Crimes Act. I mean, we can enforce that. That's part of the Federal Criminal Code, is the War Crimes Act. I do want to say that it is a little disingenuous or counterintuitive for America to be arguing. I confronted this question all the time, of course, with the Rome Statute negotiations, where for the United States to basically argue, well, wait a minute, this could be used against us. And by the way, we want to be immunized to commit genocide, to commit war crimes, to commit crimes against humanity. We must be immunized. How dare think of ever prosecuting a general or the president? Well, that's a totally weak argument with everyone else in the world. I mean, we're trying to persuade them to stop doing these things and to be held accountable for it. And then we turn around and say, well, we should be immunized. Don't ever turn this against us. I have enough confidence in how we strategize things within the US government that we are not purposely executing policies of crimes against humanity against civilian populations. I think that would be very difficult to argue or to prevail with. Now, the issue of proving like a crime of torture, which is the Afghanistan situation and the Guantanamo situation, where in fact it has been established that we committed torture against detainees within the realm of Afghanistan and in Guantanamo. That's a different issue. I mean, we have obligations under the Torture Convention not to do that. We have obligations under federal criminal law not to do that. We have obligations under the Uniform Code of Military Justice not to do that. So to turn around and then argue, oh yes, but we must be immune from prosecution for committing torture because we're America, that's just a specious argument. It has no weight whatsoever anywhere else in the world. And it undermines our ability to persuade other governments not to commit these crimes.
We're basically running out of time. I thought I would just give you, Ambassador Scheffer, a minute to provide some concluding thoughts on these issues that are these weighty issues that have occupied so much of your professional life, and you've contributed an enormous amount to this discourse at so many levels as a faculty member, as a representative of the United States government, and other.
Well, thanks, Dan, and I really am looking forward to the ASU relationship in my life. I live, in Santa Fe, New Mexico. I love the Southwest. I grew up in Oklahoma on such flat land that the only hill in sight was one constructed by the U.S. Navy in World War II for target practice at the training center in Norman, Oklahoma. So, I'm born and bred in the Southwest, and so I'm very pleased with this. As to the substance of my presentation today, I would want to emphasize that one of the great challenges is to focus policymakers on these kinds of issues. Having been for 8 years in the administration of President Bill Clinton, in all of these policy circles and discussions for 8 years with my boss at that time, Secretary of State, and prior to that, Ambassador Madeleine Albright, I saw how hard it is. The policymakers have lots of things on their minds. Even the other day, and I'll close with this, Dan, I was rather distressed when President Biden, in a discussion called the Quad with, I think it was Japan and India and one other nation, he was asked, I think it was Brazil actually, he was asked by those leaders, could you share some of your COVID-19 vaccines with us? Because we need it too. And you've got 60,000 vaccines stored in a warehouse in Detroit. Could you just, share some of that? And he actually said, no, not yet. I mean, in other words, it's all for US citizens. To me, that was the wrong answer, because these are very, very difficult problems. And the United States has to establish the credibility and the trust of other nations to press on many different issues around the world. And this one is a big one for them. And we need to demonstrate our participation in this venture internationally with good faith and with good neighborliness. And that will resonate then. When we come to them and talk about an atrocity prevention issue, they'll remember what we did on this issue of COVID-19. So everything is sort of interconnected. And I would hope that we can meet that challenge in the years ahead.
Thank you so much, Ambassador Scheffer. Thank you also, Stephanie Lindquist, for the introduction, Heather Smith Kenoi, as well as Bjorn Krondorfer, and our co-sponsorship with the ASU Global Human Rights Hub and the Martin Springer Institute. And to all of you who joined us tonight, thank you for your time, and we wish you a lovely rest of your evening.
Thank you.